We need more Supreme Court justices. But we shouldn't pack it. Lessons from FDR's failed scheme and how to actually reform the court. Every so often, particularly when there are Supreme Court decisions touching on deeply partisan issues and popular conversations, politicians start talking about court packing. Both parties have their own take on this, but most lean on the switch in time that saved 9 story we all heard in school. This story, where FDR implemented a lot of New Deal programs, and then the old, stodgy Supreme Court stood in his way and struck them down. Then, under threat of being packed with new, loyal FDR justices, the Supreme Court changed their mind and started finding all of these programs constitutional. There's a bit more to this story than this, and I want to expand on FDR's uncharacteristic political loss. The version we heard in school not only leaves out key facts, but undersells the moral of the story. Court packing to remedy political losses is the wrong answer. The current Supreme Court needs reforms, and I think adding justices, combined with term limits, is the right answer. But we need to do so in a different way than simply packing, and we need to do so for very different reasons than winning ideological battles. A president almost beyond reproach. In 1936, FDR's New Deal policies were popular and largely successful. While the United States was not completely out of the Great Depression, things were certainly looking up. FDR's political power was at a high point. The Democrats were united, and the GOP was in shambles, split within itself, and grossly unpopular. When FDR accepted his nomination at the Democratic National Convention, he gave his famous Rendezvous with Destiny speech. Governments can err. Presidents do make mistakes, but the immortal Dante tells us that divine justice weighs the sins of the cold-blooded and the sins of the warm-hearted in different scales. Better are the occasional faults of a government that lives in a spirit of charity than the consistent omissions of a government frozen in the ice of its own indifference. There's a mysterious cycle in human events. To some generations much is given, of other generations much is expected. This generation of Americans has a rendezvous with destiny. FDR cruised to victory and continued to introduce New Deal legislation. A court in transition. The Supreme Court in the 1930s was a bit of a mixed ideological bag, slowly emerging from the Lochner era, where the court upheld laissez-faire economics and racial segregation. While they were old, Justice Brandeis, the oldest, was 80, 5 were in their 70s, and Justice Owen Roberts, the youngest, was 61. They were not the stodgy old conservatives they are often made out to be. That story might be a product of FDR's frustration of being the only president since James Monroe to serve 4 years without making a single appointment to the court. 4 justices were certainly of the Lochner-era mindset, and therefore could be characterized, though not always, as anti-New Deal. These were Justices Butler, McReynolds, Sutherland, and Van Devanter. 3 were liberals, and frequently, though not always, sided with New Deal legislation. These were Justice Brandeis, Cardozo, and Stone. The remaining 2, Chief Justice Hughes and Justice Roberts, were swing votes. Justice Roberts notoriously switched sides on multiple issues. During FDR's first term, the court ruled that 6 pieces of New Deal legislation were unconstitutional. 4 were either unanimous decisions or nearly unanimous, and only 2 had a 5-4 split. Yet, it also upheld major pieces of both federal and state New Deal legislation, including the Tennessee Valley Authority, price freezes, and broad powers of foreign affairs. The court also began a decades-long march in the defense of civil liberties. From Gene Edward Smith's FDR. It reversed 100 years of precedent to hold the First Amendment's guarantee of a free press applicable to the states. It overturned rape convictions of 9 young black men in Scottsboro, Alabama. It made the Sixth Amendment's right to counsel applicable to the states in capital cases. When the young men were tried again and convicted by an all-white jury, a unanimous court overturned that conviction as well. It also unanimously defended the rights of communists to organize. The difference between what the court upheld and what it disposed of was largely due to the quality of drafting. Lots of New Deal legislation was often hastily drafted and quickly pushed through Congress. The Chief Justice said in the midst of the court packing scheme, "I'm not interested in who are to be the members of the court. I am interested in the court as an institution, and this proposed bill would destroy the court as an institution. If we had an attorney general in whom the president had confidence, and in whom the court had confidence, and in whom the people had confidence, the story might have been different. But the laws have been poorly drafted, the briefs have been badly drawn, and the arguments have been poorly presented. We've had to be not only the court, but we've had to do the work that should have been done by the attorney general." The scheme. Despite the victories, FDR still looked at the court as something standing in his way, and instead of attacking the court on the merits of their decision or taking responsibility for the hastily drafted legislation, he attacked the court in a backhanded way by saying they were too old and they couldn't keep up with their workload. This was empirically false, but it was his story and he stuck with it. The court plan is not liberal. A liberal cause was never won by stacking a deck of cards, by stuffing a ballot box, or by packing a court. Senator Wheeler, first senator to endorse FDR in 1932, and the leading opposition against the court packing proposal. When the court packing legislation was introduced in Congress in 1937, via a letter from FDR, the reaction was far from favorable. Liberals and strong FDR backers were astonished and shocked that they had not been consulted. In the Senate, Vice President Garner held his nose and turned his thumb upside down as the message was read. The Supreme Court was likewise shocked and betrayed, and the justices from across the spectrum, including liberal Justice Brandeis, opposed the move. Some folks, coincidentally, the next Supreme Court Justice pick, Hugo Black, who was at the time an Alabama senator, rallied around the bill. But overall, people were anywhere from uncomfortable to flat out opposed to it. The bill was never going to pass. A switch, but not one in time. So the court packing scheme was already a dead letter, despite FDR's immense political capital. What happened next, the so-called switch in time, is where the Supreme Court failed magnificently in a matter of optics. The Supreme Court heard a case, West Coast Hotel Company v. Parrish, in 1936. This was a case dealing with the Washington state minimum wage law. The court, in December of 1936, months before anyone knew of the court packing scheme, voted to uphold the law 4-4. Justice Roberts, the conservative swing vote, voted for the bill. Roberts definitely flip-flopped on this issue. He voted in favor of striking down a very similar New York law 6 months earlier. Yet he voted to uphold a similar legal principle in the 1934 case, Nebbia v. New York. Why did Justice Roberts change his vote 3 times in 2 years? It is unclear. The only thing we know for certain is that he did not change it because he thought the court was threatened by FDR. Unfortunately for the court, and all our understanding of what happened, Justice Stone was sick that December, so the Chief Justice delayed the vote and the subsequent reading of the decision until the spring of 1937, giving the impression that the Supreme Court was changing its tune at the behest of the president. To pile on the evidence against our popular understanding of the story, FDR continued to fight to pack the court, despite everyone wanting him to stop. It was as if FDR couldn't accept defeat, even in a practical victory. Ironically, about a year or so later, FDR got his first Supreme Court pick, one of 9 he would ultimately appoint. The court's independence survived, and over the next 60 years, it brought in justices from all over the country and from a wide range of political ideology and judicial philosophy. But over the last 20 to 25 years, that geographic and intellectual diversity has eroded. Reform. The Supreme Court needs reforming. It is too highly concentrated with DC insiders, basically a Harvard and Yale alumni club, and there's something frustrating about getting stuck with a justice for 30-plus years with no recourse. Before I lay out my case for the need for 13 justices, I want to make one thing clear. Supreme Court reform is not going to fix this country's inherent structural political problems. There are many different ways Congress can check the Supreme Court. There have been multiple opportunities to pass legislation to protect rights or overturn decisions, and our representatives have failed in that respect. No amount of court packing will replace enshrining protections in legislation or the Constitution. That aside, I want to make the case that 13 justices, combined with term limits or a mandatory age requirement, is the right amount. We need to have one justice from each circuit, the only way to make the court more responsive to the different segments of the population. An East Coast club. Despite ideological or perhaps partisan differences, there is not much geographic diversity among the Supreme Court justices. 4 justices came from the D.C. Circuit, and one, Justice Kagan, was not a judge before being appointed, but the Solicitor General of the United States, a highly D.C.-centric job. 2 more justices have experience rooted on the East Coast, with service on the Second and Third Circuits. Barrett and Gorsuch are the only ones who break this model, having served on the 7th and 10th Circuits. Additionally, the court and the entire federal judiciary are largely fed by Harvard, Yale, and a handful of other private schools. Here's some statistics. 8 of 9 of our current Supreme Court justices went to either Harvard or Yale. Since 2000, 30% of all federal judicial appointees came from either Harvard, Yale, or Columbia. 70% of federal judges got their JD from a private school. The last time a justice attended a public school was Justice Hugo Black, who attended Alabama School of Law. He was appointed in 1937 and died in 1971. Each circuit has its own case law and idiosyncratic dockets. For example, the 9th and 5th circuits have massive immigration caseloads, while the 2nd Circuit has more financial matters on its docket. The 10th Circuit, containing Oklahoma and the so-called Mountain West, has a larger share of American Indian law. Caseloads and specialty laws aside, I think it is safe to say that a justice who has spent time on a circuit, or in any state west of the Hudson or Potomac for that matter, may have, at least in theory, a more nuanced understanding of the issues facing those states. Here's a snapshot of what I mean. The court just made a pivotal decision on the Voting Rights Act. Only 2 justices were born in the South, and none served on a circuit where this decision will have an outsized impact. Likewise, the court made some decisions when it comes to immigration. None served on the 9th or 5th Circuit, where all the southern border states, except for Arizona, are, and thus a lot of the immigration law is made and heard. On a more positive note is Justice Gorsuch's experience in American Indian law, a historically neglected area of law, and the expertise he brings to the court. So how do we ensure that the Supreme Court is more attuned to the laws, customs, and issues facing different regions of our country? By requiring 13 seats on the Supreme Court, with each seat overseeing one of the 13 circuits. Then, by instituting a requirement that the Supreme Court justice overseeing the circuit they are assigned must have served in a federal circuit, either on the federal bench or on the state Supreme Court, for 5 years before being eligible for appointment to that seat. I can't say for certain how much requiring a Supreme Court justice to come from the circuit they represent will increase the court's scholastic diversity, but it will begin to force more diverse legal experiences onto the court than we already have. Adding these justices to the Supreme Court doesn't have to turn into court packing. You can add them slowly, 1 or 2 at a time, spread out over a handful of midterm and presidential elections. If you combine this reform with 18-year term limits, you would end up with a staggered system, much like the Senate, allowing for a smoother system that is both consistently responsive to the electorate, attuned to the unique legal issues that face different areas of our country, and somewhat insulated from day-to-day politicking. None of this is to say political power isn't key in driving the country in the right direction, or that the Supreme Court is really above politics. The goal, however, can't be to bludgeon a branch of government into submission. Turning the court into a rubber stamp for a political party is the wrong move. If we want to continue to govern ourselves, we need to figure out how to strengthen the system of checks and balances while not sacrificing responsiveness and representativeness. There is a way to have both. And if we look beyond FDR's court packing scheme to the rest of his time in office, we can see the answer: structural reforms, a responsive Congress, and political will. I leaned heavily on 2 sources for this research. One, Scorpions by Noah Feldman, a fantastic book on the personalities of Roberts, Frankfurt, Black, and Douglas, and FDR by Gene Edward Smith, a totem of a book, but a superb biography of FDR. If you like this podcast, please subscribe to Pioneering Oversight at pioneeringoversight.com.